forward. Okay, welcome to the Budget, Education, and City Service Committee of CB5, BEX for short. I'm Julie Chou, the Vice Chair of the committee, and I'll be chairing tonight's BEX committee meeting. This evening, we have 3 items on the agenda. First is an action item, which is a discussion of a bill sponsored by Councilmember Rivera, which entitles qualified entities an opportunity to purchase residential buildings that are for sale. Second, we have another action item, which is a package of bills sponsored by Councilmember Powers that focus on our #1 complaint in the district, which is noise. These bills will require that noise inspection reports be provided upon request, that construction noise be measured when the complaint is made, and that the city publish the results of noise complaints within 24 hours. And finally, we will have a presentation by Enliven NYC, a presentation from Chashama, a nonprofit that repurposes unused real estate into space for artists, nonprofits, and small businesses. So a brief overview of how the committee works. Each presenter will speak about the issue. After the presentation is concluded, the committee will be permitted to ask questions of the presenter. When all the committee's questions have been answered, members of the public will be permitted to ask questions of the presenter. Once all questions have been addressed, the committee will go into business session. This is when only members of the BEX committee discuss the issue amongst themselves and determine what action to take. So BEX is somewhat different from our other committees in that we do not have our applications, so that our determinations are not as straightforward. We may decide to draft a resolution to support an issue. We may decide to draft a resolution to not support the issue, or we may simply decide to seek further information or use the presentation to inform our collective knowledge. If the issue is an action item and the committee passes a resolution, it will be voted upon by all present members of BEX. Should the resolution pass, we will then be presented to full CB5 board for a vote on April 27th, and that vote is the final position of the board. So let's begin. Evan, you are assigned the bill by Councilmember Rivera. And members of the committee, you've been provided with details of the bill, but Evan, perhaps you could summarize, and then Jeremy from Councilmember Rivera's office can provide additional information and answer some of our questions. And we also have someone from REVME who will speak as well.
Sure. So in the spirit of acknowledging that we are fortunate to be joined by two people with potentially differing perspectives on the bill, Ryan, as you mentioned, from the Real Estate Board of New York, and Jeremy from Councilmember Rivera's office. I won't spend much time summarizing it because Jeremy and his boss wrote it. And so they are far better positioned to do so than I am. So my thought was, Jeremy, if you wouldn't mind walking through at a high level the purpose and mechanics of the proposed bill, and maybe briefly mentioning the not parallel but similar in spirit bill that is being carried in the state legislature, just so we understand there's a difference between the two. And then we can provide some time to Ryan to, walk through some of the concerns surrounding that proposed legislation, if that works.
That works for me.
Julie, I don't know if you want to MC that or if we could just throw it to Jeremy.
Yeah, go ahead, Jeremy.
Okay. Thanks, Julie and Evan. Can you guys all hear me okay?
Yes.
Great. So yeah, I really appreciate BEX considering proposing a resolution of support in favor of Intro 1977, which we like to call the Community Opportunity to Purchase Act, or COPA for short, and that's how I'm probably going to be referring to it throughout the presentation today. I'm getting some weird feedback.
Yeah, I was gonna suggest, if you're not on mute and your name isn't Jeremy, it might be helpful if you go on mute, just so all we hear is Jeremy.
Thanks, Evan. Okay, that's good. And feel free to raise your hands if you during the presentation.
But Jeremy, now you've gone on mute, so now we hear nothing.
Apologies. Now Now I'm talking. What I was gonna say is, if anyone raises their hands, I'll try and keep an eye out for it. And if Evan, you can just flag for me, I'm happy to halt to answer any questions as they come up. But yeah, so the Community Opportunity to Purchase Act, or COPA, is a bill that we worked on a lot, you know, in 2019, late 2019 into 2020, to address the councilwoman's #1 concern, which is access to affordable housing in District 2 in New York City as a whole. Obviously, I think we all know that New York City for a long time has been in a serious housing crisis. And I think COVID-19 only exacerbated that situation for so many New Yorkers. We now know that, according to studies, that New York tenants owe over $1 billion in unpaid rent because of COVID-19 economic effects, job loss, healthcare costs, trying to pay for a family member, continued increases in raises in rent in some cases, particularly on the lower level. I know we've all heard the kind of talk of lower rents across the city, but in a lot of cases, that's more for those kind of middle income or higher income apartments. Many of the apartments at the lower end of the spectrum have continued to rise in rent or remain steady, which for those New Yorkers living on the edge is obviously very difficult. And I think that why we think the Community Opportunity to Purchase Act is so important right now at this juncture is that we've seen in the past when you've had a chaotic market, you know, after 9/11 or, you know, the Great Recession of 2008, you will see private equity and real estate firms be in a better case to swoop in if a property goes on the market, you know, at a lower or cheaper rate than it normally would, or if there's record low interest rates like there are now. And they will swoop up, grab those properties before other people that might create affordable housing or community-based housing have the opportunity to at least put a bid in. You know, we saw in 2008 that private equity and hedge funds who received plenty of government tax breaks at the time rush in, spend more than $36 billion to purchase more than 200,000 foreclosed homes across the United States. And that had a significant effect in decreasing home ownership nationwide. And obviously, I think that issue is just as, you know, is prevalent in many different ways in New York because we're dealing with multifamily housing. And when we have those buildings being sold at a low rate, you know, it's not affecting one household. We're talking about multiple homes there. What COPA does that we think is really exciting is it gives certain nonprofit affordable housing developers, community developers, and community land trusts the opportunity, the knowledge, and the flexibility to be able to come out, and if a property gets listed on the open market, and this can be any multifamily privately owned property, if they put it on the market, they have to notify the city and provide a certain window of time, about 120 days, for a list of community-based organizations, affordable housing developers, to submit a market rate offer to purchase that property. And you might say, well, what, you know, for one, I guess the first question would be, and I know Evan brought this up to me, who are these folks? Are there really this many organizations? There actually are quite a few organizations. You know, one I can think of right in our neighborhood is Asian Americans for Equality, is a local community-based organization that also develops affordable housing. Right now, they're developing a new property on East 3rd Street in the East Village. It's 100% affordable housing. Going to be about, I think, 10 stories tall, that the councilwoman is really excited to see get completed later this year. And that's just one of a number of organizations. You have other organizations like Supportive Housing Network for New York, which is kind of a larger group that represents a number of supportive housing developers. They've come out in support for the bill. And then, you know, there's other, you know, there's Community Land Trust. We have a Community Land Trust in District 2 called the Cooper Square Community Land Trust that collectively works with the city and state and federal government to secure financing to purchase property. And then that property and the land that property sits on is owned collectively by the residents of that building and the other residents in other buildings of the entire community land trust in that regard, and Councilwoman is advocating for multiple community land trusts to open citywide in the years to come. She's provided hundreds of, actually millions of dollars towards that effort over her last 3.5 years in the council. So what basically happens again with COPA is any of those entities, they hear a property is on the market, they can put a claim in for a market offer, and the developer must consider that market offer seriously and fairly before they consider any other offers. And the reason that's so important is that what that does is it gives these entities, which often have to apply for numerous grants or federal loans to secure the money to make that offer, they need a little more time and flexibility to do that. It's not as simple as just going, for a larger commercial developer to go around. They have probably a lot more capital, have a lot more ease to make that purchase quickly, and often in many cases, those for-profit developers, they may know a property is going on the market, and it may never actually appear on any sort of listing service. That's what's called a pocket listing, where a real estate transaction happens off of a listing service. So what COPA really does is it allows these nonprofit affordable housing developers the ability to know the scale of the market, and when they decide that a property is right for their organization, for them to be able to develop affordable housing on it, it allows for them to put a fair market value offer in. It gives them the time and flexibility to put together the funding stream and sources to make that offer. Now you might say, well, what's a fair market offer? And that's a very good question. I think that the way that would work basically is, they're supposed to be looking at the entire New York City real estate market. The market is very expensive, so this isn't going to be something that is going to lead to affordable housing developers being able to access hundreds of new, putting hundreds of offers a year. We do not expect it to be that kind of a situation. The reason why an affordable housing developer is going to have to put in a really serious offer, a truly market rate offer, is that if they were to try to undercut them to put in a very low market rate offer, the owner of that property could file a lawsuit, which could incur serious legal costs for that affordable housing developer. And also, if an affordable housing developer wants to participate in this program, they have to be on a qualified list that the city's Housing and Preservation Development Agency will maintain. And if a affordable housing developer is not complying with this rule, and they're continuously putting in, under market rate offers, they can be removed from that list. And I think that that's going to be a very, very serious kind of carrot and stick approach to make sure that these groups are kind of following those rules. And so, the last thing I'll say before I kind of turn it over to Ryan, because I do want to make sure we kind of get to questions as quickly as possible, is this isn't a new idea. Cities like Washington, D.C. and San Francisco have had forms of COPA on the books for various amounts of time now. That legislation has not interrupted the real estate market in either city. It has led to affordable housing projects moving forward that might not have otherwise moved forward without COPA. And I will also say, COPA is not a silver bullet. COPA will only be successful if we have increased funding from the city, from the state, and from the federal government. Right now, the Hpd Capital Budget, which got cut $40 billion last year, we're going to be fighting to restore that budget, to expand that budget. We need to be investing more money into community land trusts at the city level. The state needs to be making a significant more of a commitment to this, in the federal government, which has a huge infrastructure package that the president is now considering, which is potentially going to have funding in it for over 1 million affordable homes, according to recent announcements. That's the kind of funding we're going to need to combine with COPA to make this a really, really successful program. And the last thing I'll just mention, since Evan wanted me to mention it, COPA is one of two bills. There's a second bill at the state level called the Tenant Opportunity to Purchase Act, or TOPA. That bill is sponsored by State Senator Zellner Myrie. We support that bill. That bill is basically a COPA, except instead of having these community organizations they get highlighted, being able to put in bids. What that does is it lets the tenants of a building come together, form an association, and put an offer in on their building if their building goes up for sale. We certainly hope that State Senator Myrie's bill passes. However, I think it's really important to pass our bill now as quickly as possible, because many of these organizations that would benefit from our bill are very well established. They've been doing affordable housing for decades. They know the difficult policy and financial challenges and building logistical challenges of purchasing a building and then redeveloping, remodeling, and maintaining the building, that tenant associations are going to take a lot longer to be able to develop. That's going to take a lot of work with community-based organizations and experts, and we support that effort. But I think COPA at this time is really what we should be focusing our energy on, getting that done as quickly as possible. And if TOPA can get past the state level, that's great too, and we'd really support that. So that's my spiel. Happy to turn it over to Ryan now and then take questions later.
Thanks, Jeremy. Go ahead, Ryan.
Thanks. Well, first off, thanks for having me this evening. And it's great to join Jeremy in talking about this legislation. I'm going to actually post, we had testimony on this here earlier when it was up for a hearing. I'll put that in the chat box in case folks want to read that later, but I'm happy to give our approach to this. You know, I think first and foremost, it's incredibly admirable in regards to what Councilwoman Rivera is doing and what she's proposed. I think we all need to prioritize and look at all options for creating homeownership as it pertains to TOPA, as Jeremy mentioned, the legislation at the state level, or incentivizing non-for-profits to be in a position to, you know, create or preserve affordable housing for our city residents. You know, we got to look at reality though. You know, while non-for-profit developers or affordable housing providers are important for the city, the vast majority of affordable housing, particularly in recent years, has been created or preserved by for-profit developers or in joint ventures between non-for-profit and for-profits. As you can imagine, as Jeremy had mentioned, I mean, this is a capital-intensive business and a capital-intensive need to create housing in our city. And you know, unfortunately, right now, as it stands, COPA does not allow for any participation of for-profits, which we believe is to the detriment of tenants, right? I mean, if there's opportunities for joint ventures between non-for-profits and for-profits, which we see across the city successfully in ways to create affordable housing, you're going to see far less opportunity for COPA to actually work. And so, you know, that's one of the things that we focus in on our testimony here when the bill came up. Additionally, I think, you know, and this might change, of course, in the fiscal year 2022 budget, but as it pertains right now, Hpd doesn't have the resources necessary to facilitate COPA. And as you can imagine, you know, this is going to be, and I think Jeremy mentioned this also, it is quite a challenge. I mean, regardless of how many sales come up year over year, to be able to facilitate these and to allow for the framework and the bureaucracy that it would entail does require a lot of infrastructure, particularly at Hpd. And so, you know, that's something that needs to be taken into consideration, as well as the interplay in regards to Hpd's involvement with properties currently, right? You know, some of these projects might be subject to triple regulation, which is fairly inefficient. So we really need to think about these things and what it will entail in regards to transactions happening in our city. And I'd be disingenuous in saying that as it pertains to a lot of owners, you know, this is quite a concern, right? I mean, the market is already subject to instability due to the pandemic, creating additional hurdles that might not actually benefit non-for-profits or tenants is of somewhat concern. And then finally, and I think this is probably the largest thing I want to say today is, you know, there is a failure to take into consideration the Martin Act, which, you know, many folks who have been in and around, you know, whether it be a cooperative unit or a condo unit, you know, New York's Blue Sky Law regulates the public offer and sale of real estate securities, right? Which would include potential group purchases of the properties as it pertains to TOPA, or in regards to non-for-profits who are looking to purchase property as well. And so, this is a pretty strenuous process. It takes time to go through the New York Attorney General's office. That in many ways, particularly as it pertains to TOPA, would create a years-long process in regards to providing for transaction of a property. We actually have landlords who are members of Revenue who are willing to work with very credible non-for-profits to convert rent-regulated properties to HDFC cooperatives, for example. And because of the Martin Act in particular, it has become, in many ways, virtually impossible to really make it work in a way that is beneficial and allows for a transaction in a seamless way. So what I'm getting at is, if we want something like TOPA or COPA to work, we really need to iron out the current framework in place as it pertains to the Martin Act, as well as, other regulations relevant to Hpd that are currently in place that would make it somewhat difficult for these transactions to be facilitated. One idea is to make COPA voluntary, at least to begin with, to see if there's opportunities and if indeed there are non-for-profit organizations that will actually successfully create affordable housing opportunities through these type of purchases. Outside of that, I think we feel like there's real concern that this in fact will not work as effectively as what is being stated. In regard, it will actually hamper the ability for affordable housing to be preserved or created here in the city. And so, again, we really appreciate Councilwoman Rivera's prioritization of this effort. I think we need to make sure that we do it the right way and in a way that doesn't create additional hurdles for the market to the detriment of tenants and non-for-profits here in the city. So I'll leave it at that. I left our testimony in the chat box. Happy to take any questions folks might have.
Okay, thanks, Ryan. Members of the committee, does anyone have any questions? Tristan?
Hi, thank you both for joining us. Jeremy, could you elaborate on what you said earlier about how if a qualified entity submits an offer at an under market price, the recourse is litigation? Did I hear that correctly, or could you elaborate on that?
Yeah, that would be correct. They could also, if they would also be able to report them to the qualified entity to Hpd. And if Hpd investigated and affirmed that situation, they could have them removed from the qualified list so that they could no longer submit offers going forward.
Thank you.
Evan?
So maybe to piggyback off of that question, I maybe just misunderstood again the mechanics of how this is supposed to work, but my sense was that the main purpose of the bill was to allow this 120-day window for community-based organizations and nonprofits to, gather the resources necessary, namely financing, to compete with private developers in bidding on properties put up for sale, and that the onus on owners would be just the time of waiting that 120 days instead of immediately engaging with private offers. But that I guess this is the question. What happens when, let's say a building in New York, let's just pretend for a second, costs $100. The fair market value of a building is $100, and some nonprofit offers $99 during that 100-day window. What options does a landlord have or an owner have to say, I want to see what else is out there. Mm-hmm. Let me see if a competing bid is greater than what I've just received from the nonprofit.
That's a really good point. I should have clarified that. They are more well within their right to take another offer. If another for-profit developer to come in at the end of that 120-day period and offer $101, they are more than able to take that offer. There is no threshold or thing that says if they offer the fair market value, that they have to take that fair market value. What it offers is time, so that if someone does put in that fair market value offer, that they can actually put in a real bid and negotiate with that developer. That's really what it does. There is nothing that says they are required to take one offer, the offer of the affordable housing developer in this case, versus if a similar or if a better offer comes on the table.
So then to Tristan's earlier question, I guess what I'm failing to understand is like what is the penalty to a nonprofit for underbidding what someone is going to determine is the fair market value if an owner can just say no? Is it because the owner doesn't actually have to wait the 120 days if there's no bid from a nonprofit, and that by putting forth any offer at all, you're sort of like wasting time and you should be penalized for that if you're not doing so in good faith? Or is there something else?
Yeah, it's basically that. So if someone puts in an offer at 120 days, they get 60 more days to negotiate on that offer. So again, if someone were to put in a below market value offer, that's 60 extra days. Then the developer, 180 days total, the developer then has to wait before they can consider other bids. And obviously, we don't want to have a situation where that's occurring in the framework of this bill. And so that's kind of the main point. So again, if we are trying to discourage that, again, we think that effectively is done via the fact of this kind of qualified list of entities and kind of maintaining that list.
Joseph?
So I'm sorry if you already covered this, Jeremy. I was trying to listen and kind of like look at the language in the bill at the same time. But so the fair market value, who is the arbiter of that? Is that just based off of an appraisal or multiple appraisals? Because you know that there's a lot of gray area there. I guess I worry about a nonprofit, submitting what they think is a fair bid. If it comes in under some later appraisal, I wouldn't want them to be vulnerable to, litigation or penalties or anything like that.
Mm-hmm. Yeah, I mean, I think there's 2 points to it. One, I think, the way we have it in the bill currently, the appraiser would it would be done through litigation. If the landlord, if the property owner said that the offer was below fair market and the affordable housing developer disagreed, they would take them to court. Vice versa, similarly, if the affordable housing developer submitted something and the property owner said that that's a below fair market value, I shouldn't have to wait the 60 extra days. Litigation would be the option. And I'll give you some background on it, just a little bit of our kind of thought process on the bill. There was a previous version of this bill that had been passed, I think in 2005 in the city council. It had a appraisal process within that bill. That bill was shot down for preemption issues. When we reworked the bill, we viewed that this option helped strengthen our position in terms of the council's authority to do this. And we also think that litigation is an effective avenue for settling these kinds of disputes. We do not think that they would particularly be occurring that often, because we don't think that this is going to be something that nonprofits are going to be doing, 10s or 20s or 30 of these applications every year. We think collectively, this is not going to be something that's going to immediately take off with like 100 applications from a group. And we think that these groups are going to be very responsible because they've worked with Hpd and they want to maintain their position on these lists.
Thanks. And Julie, can I ask a second question? So the 120-day period, I guess, was there any back and forth about the time period that we would kind of land on in the bill? Why 120 days?
It was just a number that we kind of just developed internally with our policy team, factoring and kind of trying to just balance the amount of time that it takes to develop to secure those, to start initially securing those finances with the needs of the developer. It's a number that I think we'll continue to talk about with interested parties. The bill has had a hearing already, so now that we've had a hearing, before any vote, we'll certainly sit down with City Hall and with impacted stakeholders to kind of talk about any amendments to the bill. Certainly think that's something we would be happy to continue to discuss. Another thing that Ryan brought up was the fact that the bill currently does not allow for-profit affordable housing developers, which there are for-profit affordable housing developers. A group is, for example, like that is L&M Developing Partners. They develop thousands of affordable housing units in New York City and across the country every year. They came and testified, others came and testified, and we're going to continue our conversations with them. The councilwoman, I think, is very open to, to having that continued discussion. At the same time, groups like the Association for Neighborhood Housing and Development, which is a affordable housing and kind of community development policy organization, they kind of testified to some of the concerns they had with for-profit developers being involved, that it may not, they may not often do the kinds of community investments, community focused approach to housing that they're kind of wanting to see. So, we're going to continue to have all those kinds of discussions. I don't think, the bill in its current form is the, final version it needs to be.
Any other questions? Okay. No, well, we can open it up to members of the public. Members of the public, if you have any questions, please raise your hand. I'm not seeing any. So we can go into business session. Who wants to start? Evan, I don't know if you did the most research on this bill.
Sure. And thanks again to both Jeremy and Ryan for chatting with us today. I guess my sense is that the bill is not yet fully baked. And so before commenting on it generally, I guess one question for the committee to keep in mind is if we're inclined to support this in theory, like how do you do that if you might be supporting a bill that looks different than how it does today 3 months from now. So just maybe we keep that in the back of our mind. With that said, like I think that there are certainly aspects of this that make a lot of sense. And in theory, empowering community-based organizations to have an opportunity to compete with private developers in the purchase and sale of buildings makes a ton of sense and sort of like leads us towards the dream of more affordable housing. Whether that actually happens in practice, as Jeremy has been, to his credit, very honest about, is a very open question. And my, it's not lost on me that at least when we had this debate over, brokers' fees in the rental market, REBNY's position was a lot more strident than it is here in terms of being against the bill. So maybe there's something to the fact that, not to speak for Ryan, but there are aspects of this that seem like have opportunities for universal agreement that may not exist in most city-led legislation involving real estate ventures. So, I find myself in favor of the bill in spirit. I'm a little concerned that we don't totally know what that bill is going to look like, in the end, whether that's including more for-profit developers who have a focus on affordable housing, whether that's allowing for joint ventures, I don't know. And my sense is that there's a lot of effort going into a bill that may not see any positive effects for some time because there's just not funding to actually police any of this. But, again, if we had a resolution in support of this sort of at a high level, I could be supportive of that.
Sounds good. I think Rachel was next. Or Jeremy, did you have any comments to?
Sorry. I just wanted to just correct one small thing there. From whatever, I think everything Evan said was totally, great, and I understand what he's saying. There was one point at the end, and sorry, I am now blinking because I got another text message at the exact same time, around the effect it would have. I would just say that, we think it's going to be particularly really strong, and that in terms of the saying that the bill may change from something to another, than in terms of like adding in for-profit affordable housing developers. When we say for-profit, we mean specifically developers who are for-profit, but they are specifically building only affordable housing in most cases. Anything that would be done on this bill, it would be 100% affordable housing. No developer in any version of this bill that we've talked about, that's anyone that's kind of mentioned, would be any sort of like mixed use, MIH style, some for-profit, some affordable. Like, that's not in the cards. It's really just a question of like whether the organization itself is a for-profit entity or a non-for-profit entity. Any property that's going to be developed through this has to be 100% affordable housing. So I just wanted to clarify that.
Thanks, Jeremy. And I see Ryan raised his hand. I don't know if Ryan, you have a specific.
Yeah, no, I'll just piggyback off that very quickly. I mean, look, like it is a matter of dollars and cents, right? And again, we want to prioritize opportunities for affordable housing across the city. I think when you start to delineate in regards to what type of entity can work in a joint venture, you're going to dilute the opportunity for that type of affordable housing that you want in the city. So that's great. I mean, it might be also an idea to look at, in particular, what types of residential properties would be subject to this type of proposal. Because, I mean, if you're looking to make any residential property over 3 units, which is what currently the bill does, subject to COPA, I just don't think you're going to get non-for-profits, even if it is with a joint venture. If you do try to include for-profit entities as part of a JV, you're just not going to get that type of interest across, and it's just going to create additional barriers for residential transactions, which, to be frank, will work to the detriment of tenants. And so I think we got to be very careful. Again, we want to incentivize and provide opportunities for non-for-profit entities to work within their own communities, but it can't be to the detriment of folks who are trying to do the right thing in the for-profit sector that could be positive for tenants. And so I just want to leave it at that. I think you're right in regards to this bill needs a lot of conversation still, and we're happy to be a part of that conversation and go forth from there. But we got to be very understanding of what it takes to create affordable housing, and that's capital.
Excuse me, Julie.
Sorry, yes.
Yes, hi, this is Vicky Barbero, Chair. I just want to remind everyone that you're in business session. And at that time, the applicant can only be recognized by the chair to make clarification, which Jeremy did do. So you are in business session now. And then I'll talk a little bit later about the overall procedure at the end of this. But
Okay.
It's just a reminder right now, okay?
Okay, thanks, Vicky. So we have Rachel, and then we'll do Joseph, Tristan, and then Mary. Go ahead, Rachel.
Yeah, Evan, I appreciated all your points. I'm a little bit torn because I also do really support the idea in theory. I guess I'm kind of held up with the time limitations of, a third of the year or so spent to delay the process of building housing. I guess just everything I've read about affordable housing and learned about it is that the more time delays put in place, just the housing doesn't get built, the longer it takes to build it. So I don't know if others have thoughts on that. But yeah, I agree. It seems a little bit unclear how it would work in practice, although the idea is a good one.
Joseph.
Yeah. Thank you, Evan, for bringing this to us. I think this is fascinating. I would strongly support this bill, potentially with a change or two. And I guess I want to speak from my experience. I work for a nonprofit that would probably be a qualified entity. We do supportive housing. I've been with them for almost 5 years. We've done our own development, purchasing land. We've also been part of joint venture supportive housing developments. So I've had a lot of experience with these issues. And I would like to say that I think it's important that the definition of a qualified entity remain strictly not-for-profits. And it's not because there are not good private entities out there that develop affordable housing. It's because I think this bill would ideally help correct, a severe disadvantage that the nonprofits have, which is a lack of capital, right? Everyone knows that we have a lack of capital, so we have to go to the city, the state, some other source of financing to get like down payment capital, acquisition capital. That does take a little time. We often have volunteer boards of directors that we need to convene to make any sort of acquisition decision. So I think it's reasonable to say that, we need to slow the process a little bit to give nonprofits time to submit a fair bid on these projects. And I think it's fair to say that nonprofits need more time than even a private affordable housing developer. As to the JV issue, I don't think we should, give the same consideration to joint ventures, with a private and a nonprofit, at least the same amount of time, because, when a nonprofit is going to enter into a joint venture, they have to make a deal with the private developer pretty much up front about the terms of the deal. And the power the nonprofit has is determined by how much leverage they have. If they're not bringing any land to the deal, then they're going to have very little leverage to determine the terms of the deal. Like what kind of housing is going to be built, meaning how affordable, what does it look like, the terms of the affordability. There's just a lot there that, it would benefit the nonprofit to have land ownership and then say, hey, if we don't have the, expertise or the administrative capacity to build this ourselves, then we can bring this land that we bought, to a private developer and make a deal with them so that they get some of the benefit, but the nonprofit still keeps the land. So, I think the more that you let private entities into this arrangement, the more we're going to continue to exacerbate the kind of, inequality that I see between private developers continuing to accumulate more and more and more New York City land, which they've always done, and nonprofits continuing to kind of scramble and kind of get the scraps, like build on train tracks, build at the farthest corners of the Bronx, like, always running and trying to catch up. So the one thing that concerns me about the bill is that length of time. Like I understand that, maybe 120, 180 days is a long time to automatically stall every single transaction. So I would consider lowering that a little bit, maybe, 90 days, maybe 60 days even. But I do think it's worthwhile having at least 2 to 3 months, where nonprofits can kind of have a shot at this. Thanks.
Thanks, Joseph. Tristan?
Hey, so in terms of the stuff that I like about it, I like giving these qualified entities the ability to respond to other offers and match them. And I like the whole, overarching focus on improving this type of housing. But I agree with Joseph. I think 120 days is far too much. So I think 60 or like much lower would be more appropriate. And I really get turned off by like this focus on litigation over the valuation of the property to determine the fair market price. I think, if that's the only recourse that these owners have, that's really going to throw up barriers to moving along with the establishment of new housing. And yeah, I really did not like that whatsoever.
Thanks, Tristan. Mary.
Hey guys, thanks to both presenters tonight. I know it'll come as a surprise to absolutely no one that I'm very much in favor of this intro. I'm not gonna waste everyone's time because I think Joseph really enumerated all the reasons why it's really important to give nonprofits a leg up. When I was running the coalition, we both did extensive renovation and built from the ground up affordable housing for both single adults and for families. And I can't overstate the value in having the time that it takes to put together all the different partners that's needed to build truly affordable housing. So thank you to Councilmember Rivera, and I'm hoping that if we can settle the issue of the number of days that we could get behind this intro.
Thanks, Mary. July.
Thank you, Julie. It's not clear to me how.
July, we can't hear you very well.
How about now?
Perfect.
Can you hear me better now?
Yes.
Okay, thank you. It's not clear to me how the nonprofit entities will be competitive against private developers, considering the extraordinarily high cost of development in New York City. It's about $500 per square footage. If we're talking about land acquisition, maybe there is some room to be competitive. Again, not clear to me. The nonprofit entities, if they end up getting the right to develop and the land, they potentially will qualify for the Article 11 real estate tax exemption. That will be a loss of revenue source for the city. Now, that being said, maybe the benefit of having 100% affordable housing units outweighs the loss of revenue. I don't know. I don't know if a study has been done on this, not clear. And finally, in terms of getting additional funding from the city or the state, that funding is in place of what other programs? Are we taking funding away from other programs? Not clear to me. I agree with many of the committee members. I like the intro in spirit, in concept, but I need to see more in order to support it. Thank you.
Thanks, July. Evan?
Oh, sorry. I think maybe I didn't take my hand down last time. Well, while you called me, just quickly to Tristan's point about litigation, I would generally agree that would create sort of like a concerning dynamic, but that struck me more as frankly silly than concerning, because if all we're talking about is like litigating over the right to have 60 more days to negotiate, no one is going to file that lawsuit because it will take many, many months more than just 60 days to like resolve that dispute. And any sort of like commercially minded person would just be annoyed and wait the 60 days. I assumed it was more for like repeat bad actor nonprofits, if those ever existed, where like all they were doing was just like sticking it to the owners by putting dollar bids on buildings just to like make them wait 180 days. Because short of that, like no one's going to sue over 60 days, just as a realistic thing, unless I'm misunderstanding what Jeremy said there. That's the main caveat.
Okay. Is Joseph?
Sorry, I'll be quick because I talked a lot. I just thought I might respond to a couple of the questions that July raised, just from my experience. Nonprofits, they don't have a lot of capital typically on the books, but once they purchase land, that does make them eligible for billions of dollars of development capital that the city and the state allocate every year for affordable housing. So essentially buying the land kind of unlocks capital that they can use to develop the land for affordable housing. So typically that hasn't been seen as a big barrier, I think. And then for the tax exemption issue, a lot of affordable housing now is built by joint ventures. Usually those have a nonprofit partner who, has some sort of formal title to the land, allowing the whole project to be tax exempt anyway. So a lot of the, affordable housing that's already being built is not getting the city any taxes anyway. So I just wanted to add that information to the point about the loss of tax revenue.
Thanks, Joseph. July, not sure if that helps, but it sounds like we have a general consensus in support of the bill. Yeah, so is there any motion?
I'm happy to make a motion. I'm still not 100% sure what type of resolution we're talking about. But I suppose a motion for a resolution of general support, subject to folks on the committee having certain caveats or contingencies they want to throw in.
Second that.
Okay. I see Chuck actually has his hand raised.
Thank you. Then I'm going to speak in favor of the motion, which Evan, I understand to be that we support the concept of qualified buyers having the opportunity to participate in the marketplace, and we'd like the parties to move forward. So we don't have to endorse all of the specifics of the bill. We don't have to get into a discussion of 60 days or 90 days or 120 days or rewriting the bill. I think that what we can do to help Councilmember Rivera with her bill is to say we support the concept.
Right, just general support without any specific asks. Okay, so let's take it to a vote. I'm a yes. Mary?
Yes.
Joseph?
Yes.
Laura?
Yes.
Tristan?
Yes.
Is Rob here? I thought I saw him. Maybe not. Sam?
Yes.
Blaga?
Yes.
Kim?
Yes.
Okay, thanks. Evan?
Yes.
Chuck?
Yes.
Pete?
Yes.
Rachel?
Yes.
And July?
Yes.
Thank you. Okay, motion passes. Next we have Franklin Richards from Councilmember Power's office, who will speak to us about the noise bills. Each of you have been provided with the details of these bills, but perhaps Franklin, you could summarize.
Yeah, I'll give a quick summary. Thank you, Julie, for the kind introduction. So what we have today are two bills, 2180 and 2190. And basically, they're companion bills with each other. For 2180 is where the meat of the situation comes in. What it will require is DEP producing their findings of their inspections within 24 hours and for their year-long period by the January 31st. What this intends to do, and I want to emphasize this because I know it's been told to me that noise complaints are a big thing that happen in the area, and this makes everything more, one, efficient, two, transparent. So you know what is happening when someone comes to inspect. For example, a lot of times when an individual comes to inspect the noise complaint, you put in a 311 complaint, they come and inspect it, you hear that it's been resolved, but you have never seen the person there. And a lot of times what happens is an inspector will come, it'll be after the time period that the event that you were complaining about happened, and they don't see the same thing you see, or the decibel levels they were looking for isn't met. And and or they get into that location and can't get in to even inspect it in the first place. So they consider that resolved. And what this bill will help do is provide them with the avenue of presenting this information after the fact, so you know what they came for, what was the reason why they were in there. A lot of it has to go through also the DEP rulemaking process. So how they're going to present that information might come down to if and when the bill is passed, what that looks like, how they present that information. That is all being left up to DEP based on the language of the bill. But overall, it's getting them to be quicker in providing that information to you folks, so you know what is happening in that area when it comes to noise complaints. Secondly, 2190 is, as I said earlier, a companion bill, which also loops in the NYPD into this reporting procedure, because a lot of times when you put in a 311 request, or someone might reach out directly to the NYPD, they will end up addressing that noise complaint. And at the moment, the only way for you to get that report is through FOIA or FOIL, whichever way you want to pronounce the act, which is through the Freedom of Information request. And as you know, if you've ever done anything with the Freedom of Information request /law, it takes a while for you to get that information. And the 2190 helps to skip, not necessarily skip over that process, but make sure that the necessary information is provided to you. And the plain text of the bill says anyone at the moment, so it can be requested by anyone. So I think when I talked to Sarah, our legislative director, a goal is to have DEP address like private information being redacted. We don't necessarily want everyone getting all your information for a report about a noise complaint. So that's part of what 2190 would also help to do. But a lot of it goes down to DEP's rulemaking process, but the overall bill is to make it on the similar level to other departments within the city, like DOB, in providing reports within a timely manner, in this case, 24 hours. And I'm happy to take any questions. I just want to give you a quick positioning of where the bill is now. It was introduced in December. And then at the same time in December, it was sent over to the Committee on Environmental Protection. From there, we are still waiting to get a hearing date for the bill. Once there's a hearing date for the bill, if you are in support for the bill, it'll be great if you can testify in front of the committee. And then at one of the upcoming meetings after it goes through the committee meeting, if it's voted out, it will then go to a stated meeting, one of those upcoming stated meetings, and it will be voted on by the full council. And we think it's a very straightforward bill. And we hope that it is passed, and it will take effect immediately if passed.
Thanks, Franklin. That was really helpful. Members of the committee, does anyone have any questions? Tristan?
Hi, Franklin. Could you speak a little bit about like post-inspection, your understanding of what the steps, the process that the inspectors do and their due diligence that they fill out, and then connected to that, how you guys determine that a 24-hour turnaround was like an appropriate amount of time?
That is a great question. I can't, for one, speak on where the 24-hour limit came from. I can definitely find out and get back to you on that one. But I believe it's to put it on the similar line with other departments where they have like a 24 to 48-hour timeline to turn over those reports of their inspections, make it live, as it's often coined. And can you remind me of the first half of your question again, Tristan?
Just like the stages, like their process flow, like they visit the inspector, like is there internal vetting that they have to go through before they finalize their report? Like, do they have to go through and, you know, you mentioned like censor the the private information? Is that at that stage, or would that be at the stage where you provide it to requesters?
Well, that would the part about redacting would more so be after that's requested, but the internal processes are currently they go to a site, they inspect it, and they just at the moment just say if it's resolved or not resolved. It doesn't really give you detailed notes, and then the bill offers that opportunity for you to get those detailed notes and know exactly what transcribed. Transcribed is probably not the word I was trying to use, but.
Thank you.
No problem.
And Rachel?
Yeah, sorry if you already said this, Franklin. Just want to make sure I'm super clear. So the current way that this is done now is that these aren't published at all, or are they published eventually just a lot longer than 24 hours?
From my understanding, it could be a little both. It's right now, a lot of times, as I said earlier, is that you'll get a notification that it's resolved, but a lot of times it's not resolved. They may have came during a different period of the day where the noise that you complain about is no longer happening. But it's like an event that happens daily. So there's a set period of time that you would like them to be there, but they oftentimes the inspector may come before or after that time. So it doesn't necessarily, they don't necessarily witness the event. So this will document that and say, this is why they missed it. And then they'll follow up. So instead of it just being considered resolved because they didn't actually get to see it. Secondly, a lot of times with inspections, they aren't being able to be let into places. And if they don't have the proper ability to assess the situation, they can't make a determination. But at the moment, it still says resolved. So we're trying to make sure everything is actually resolved before you label it as resolved. And if it's not being able to be resolved, you have the detailed information of why it wasn't resolved and how you can go about following up on that. Does that answer your question?
Yeah, that helps. So they would have to, in addition to responding within 24 hours, be more specific about why it was resolved, if it was resolved, or why not.
Correct.
Okay, thank you so much. Just want to check if there's any more questions from the committee. Okay, seeing none, going to open it up to the public. Members of the public can raise your hand if you have any questions. Not seeing any. So we can move into business session. Any comments? Who would like to start? Okay, I mean, I think this is a no-brainer for CB5. This is our first, our primary need, and really excited to see the bills. Tristan, and then Rachel.
Yeah, I think it's a good bill. I think my only concern would be, I think maybe 24 hours might be a bit too quick of a turnaround, especially if we're adding to like the amount of due diligence that we would have the inspectors do. So I wouldn't reject it based on that because it's just part of the process, but maybe something like a week would be more appropriate, I would think.
Okay, thanks, Tristan. Rachel?
I'm very supportive of this, Julie. Like you said, this is our #1 concern, and I think that this just provides a level of transparency that's really important.
Okay, great. Is there general support from the committee? Okay. Tristan, is that another comment? Or, okay. So is there a motion for support of the bill and maybe recommendation to extend the time from 24 hours to a week? Mary.
I guess,
Yeah, I wasn't sure. I thought maybe Tristan, correct me if I'm wrong, you just threw out a week. I don't know if we could find something in between. Maybe 48 hours is, I really have trouble with a week on a noise complaint. I'm hoping that these things will be addressed more quickly and that this bill will lead to that, plus the transparency.
Tristan, does that work for you?
yeah, or even like not even being specific about time. I just kind of feel like 24 hours is just too short, but that sounds fine. And also just a question, I saw that there's like a third bill about measurement of construction noise that I don't think was discussed. Are we taking a stance on that or just these two?
Franklin, do you mind addressing that?
What bill number was that? I can try to.
This is 1043.
1 second. I don't seem to have that in my notes at the moment. I had 2180 and 2190 on my agenda, but I can double back in a second if you give me a second. Yeah, I don't have my notes on that, but I definitely will try to get you information via email if you would like that, because I don't want to misspeak on behalf of Sarah, who is our legislative director, on the information that she would like to provide.
Thanks, Franklin. So is there a motion to support the two bills that Franklin discussed?
Motion.
Second.
Second.
Okay. Great, thank you. So let's take it to a vote. I'm a yes. Mary?
Yes.
Joseph left. Laura?
Yes.
Tristan?
Yes.
And thanks. Rob, email me, but if you're still on, Rob. Okay. How about Sam?
Yes.
Okay. Blaga?
Yes.
Tim?
Yes.
Evan?
Yes.
Chuck?
Yes.
Pete?
Yes.
Rachel?
Yes.
And July?
Yes.
Thank you. Okay, motion passes. So now we have a presentation from Chashama, which I think I saw Haley.
Hello.
Hi, Haley.
Hey, how are you? Thank you for having us tonight.
Haley, can you hear me?
Hi, Anita. Welcome.
Hey.
Perfect timing.
Thank you.
Would I be able to share my screen? Is that okay?
Yes. I don't know, Marisa, if you can give her.
I think I have access.
You actually have access. You can go ahead.
Great. Let me just present. Okay, great. Anita, whenever you're ready.
Okay. Hello, everyone. Thank you for allowing Chashama to present tonight. Next slide.
Sorry, hold on. Oh, here we go.
Chashama has been around for 25 years. We've given space to over 30,000 artists. hosted 4,000 public events, and provided 100 free art classes in underserved community. Next slide. We do this by property owners donating space to us, and then we take these spaces and give them to small businesses, artists, and nonprofits. Next slide. The way we do this is when the property owner donates the space to us, we give them a $5 million general liability insurance policy. We have flexible terms. We usually ask for 3 months upfront, and then we go month-to-month letter of agreement. We manage the facilities, and we give them good exposure and help the local economy. Next. This is a map of our current locations. You can see we are spread throughout the 5 boroughs and are growing constantly. Next slide. Currently, we are starting a new program called Storefront Startups, where we are having 15 pop-up stores from low-income community and women-owned, which will be opening starting next week and running till July. Next. We also teach free art classes in underserved communities. We've done this since we have always been around, and this program is really helps out a lot of youth, seniors, and people of all ages. Next. We give workspace to artists at a subsidized rate. Next. We have 120 exhibitions each year. Next. And we do 112 performances each year as well. Next. So if anybody has any questions or thoughts, basically what we are doing is we are Chashama on steroids. We're trying to take over 150 locations in the next 2 years to help the economy and revive New York. That is the end of our presentation.
Thank you, Anita. Looks like a great organization. Just want to check if anybody has any questions for Anita or Haley. Okay, well, thank you for coming and presenting to CB5. I just want to check with Vicky if she has any comments before we and wrap up. Okay. I think that's it then. Thank you, everyone.
Thanks, Julie.
Great job, Julie. Thank you.
Thank you. Bye.
Thanks, Julie. Bye-bye.
Thanks, Julie.
Bye, everyone. Thank you, Julie. Good job.